Mr. Brown did not have a blood test taken for his suspected DUI. However, an open container was found in the vehicle. Your Honor, state's recommendation for count one is 12 months to serve 3 days, credit for 2 days, meaning he has 1 day remaining, balance probated, a $600 fine, DUI risk reduction course.
Whoa. Slow down for me. So go back 3 days, but he's got credit for 2 days. He has 1 day to serve.
Yes, Your Honor. 1 day remaining.
Okay.
Balance probated. $100 fine.
I'm sorry, $300?
$600, Your Honor. It's a second and 10.
I'm sorry, because it's some of it is cutting in and out. That's why I was asking. Okay, so $600 fine.
Yes, Your Honor. DUI risk reduction course. 240 hours of community service.
All right.
No drugs or alcohol, subject to random testing.
Okay.
Substance abuse evaluation and any recommended treatment.
Okay.
Ignition interlock device to be used on his vehicle. Count 2 will be null prost per the agreement. Count 3 will be a $200 fine that is suspended. Count 4 will be a $100 fine that is suspended. Count 5 will be null prost per negotiations.
All right, Mr. Lynch.
Judge, that did accurately reflect the plea agreement that we are entering into. We are going to ask the court to accept it. There is the matter of the additional day in jail that is required. I guess if we could just give Mr. Brown whether he needs to turn himself in for that. I guess a date certain, so we don't have any hangups there. He understands and he's willing to do it. And so that's the only thing we ask for is just that be clarified when he needs to serve that.
All right. What is, I don't really care. What's his preference? He's working. I see he has a vest on. So what's a day he can do it?
Mr. Brown, probably in the next 2 weeks. What's the best time for you to turn yourself in and serve?
I can do it on a Saturday.
You want this coming, or we probably need to go to the next Saturday just to make sure it's processed. Is that right?
Yeah, I'm cool. Yes, you can hear me?
Yes.
Yeah.
I think Mr. Brown's indicating he's willing to do it on a Saturday. So I would say if we can do it either this Saturday or the following Saturday, if that's necessary to make sure that the jail has the proper paperwork.
Okay. Next Saturday, I guess. What date is that? Is that August or something?
So Judge, if you're referring to the
August 9th.
Okay.
Hello? August 9th.
All right.
That's fine.
Mr. will be August 9th. Is there a particular time he needs to turn himself in?
I believe it has to be by 6 p.m. Go ahead. I believe it has to be by 6 p.m.
Okay. Judge, are you waiting on us?
Yeah.
Oh, I'm sorry. So he can do that. Mr. Brown, do we need to give a specific time? Is that what you're waiting for?
6 p.m.
Okay.
All right. So, Mr. Brown, I'm going to accept your plea of guilty to count 1. That's 12 months to serve 3 days. You'll serve your remaining day on August 9th, turning yourself in at 6 p.m. You'll be released the next day by 6 p.m. Balance will be probated for you or pay a fine in the amount of $600. It's going to be a lot more than that because of the surcharges that come with the DUI. A risk reduction course, 240 hours of community service. You're to have no alcohol or illicit drugs during the course of your probation. You're subject to random screens for alcohol and drugs. You'll do a substance abuse evaluation. And if they order any treatment, you will complete that treatment. And you'll also have an interlock device as ordered by the statute. Count 3 will run concurrent with count 1, a $200 suspended fine. Count 4 will run concurrent with count 1, a $100 suspended fine. Counts 2 and 5 will be no pros. And Mr. Brown, you're counted among those people who don't believe fat meat is greasy, because this is your second DUI.
But that's what I don't smoke or drink anyway.
No, let me do this part. If you have been previously before a court for a DUI and you're before me now for a DUI, that means that you have 2 DUIs. So this is what I'm telling you. At some point, you have got to come to the understanding that you're putting your life and other people's lives at risk by being irresponsible. DUI is a choice. You make a choice. And so when people end up dead or mutilated or have a problem that results from a DUI, it's because you made a choice to do what you're doing. Now, if you didn't get convinced the first time that a DUI is not the right thing to do, and that there are other options for how you conduct yourself when you are imbibing alcohol and conducting yourself on the road, then hopefully this time will be that time that makes the impression upon you that you don't get to risk other people's lives for your fun.
That's why I don't drink or smoke, period, at all no more. I don't do anything.
And I think he's indicating, Judge, that since this incident, that he doesn't currently drink alcohol or drugs, and we've discussed it.
Yeah, but currently could change to currently could be a second ago.
And I understand that, Judge.
Is whatever you're saying right now, but that doesn't mean anything for the future. What I want Mr. Brown to consider is that he's been lucky that it's only been criminal charges as opposed to somebody being hurt or killed. So, Mr. Brown, I'm going to put you in a breakout room with Ms. James to get signed up for probation. The quickest way to get rearrested is to fail to make your probation reports. Please make sure that you do all of the things that I have ordered you to do in the special conditions of probation.
Judge, can I ask one thing? Can I that time on that 6 o'clock? Can I make that earlier on that Saturday?
I go by what the jail says. Deputy, is there a deputy in the courtroom who could tell me what time, turn-in time? Because I was always told it's not flexible because of shift change.
Can one of y'all confirm that? So he's got to turn himself into jail, and Judge is asking whether you know. So we're saying 6 p.m. I think that's when y'all do it. Do you know anything about that?
So I think the latest he could turn himself in is about 8 p.m. So
Okay.
Well, if you want to go.
He was asking about early.
So the late, I think, anytime you come in, anytime, it's 24 hours, but I know the latest you could turn yourself in is like around 8 p.m. or 9 p.m. What my judge have said, I think 8 p.m. is the latest.
Okay. So the deputies were indicating they believe the latest time would be 8 p.m., but that there may be an option to turn himself in earlier. I would just suggest, Mr. Brown, if you could just call the sheriff's office and or you can just go ahead and come turn yourself in.
We need to put a turn-in time, but I need them, if y'all would radio somebody who can tell me, that would help, because the
Deputy's gonna call a sergeant and get a confirmation there.
yeah, thank you. And Mr. Brown, just hold on for a second, and we'll get you set up with once we get you set up with Miss James. If you'll come back in here, we'll be able to tell you the time, or Mr. Lynch can give you the exact time to turn yourself in.
Okay.
All right.
Thank you.
All right, so I'm gonna put you in a breakout room with Miss James. When she is finished speaking with you, then you can pop back in here, and we should have that turn-in time for you. Okay.
Okay, cool. That'll work.
All right. 1 second. All right, the invitation should pop up on your screen. Ms. James? All right, all right. So that concludes the pleas for this calendar. So the 10 a.m. calendar is done, and we'll be back in a moment for the 11 a.m. Thank you.
Thank you, Your Honor.
Hey, Mr. Tipton, are you there?
What's up, sir? How you doing, sir? I'm all right, sir.
Mr. Tipton, I got an officer here. He wanted to make sure whether he needs to be here or not.
Which officer, sir?
So it's gonna be an officer from Kareem Rogers on the 11 o'clock. You want me to give him your contact, or you want to let him know if you need him?
Give me one moment, please. Officer Rogers, who are you here for?
This is not Officer Rogers, it's Kareem Rogers is the case. It looks like the motion was withdrawn, but I don't want to tell him nothing without you confirming that.
All right, thank you. Give me one moment, please.
Once they're like, oh, we don't have to do this, it's like, I mean, right. Right, or maybe, so you know what could have happened? She just wouldn't do it. So maybe like, it just didn't have time to realize. Get back to you.
Is that officer courtroom?
Yeah, we're here.
Is that Officer Square in the courtroom?
Officer's still here in the courtroom, yeah.
Is it Officer Square, Ronnie Square?
Is it Officer Square? Vanderpool.
Vanderpool. Okay. Give me one moment.
Good morning. This is the 11 a.m. motions calendar, criminal motions calendar for courtroom 304. I'm Judge Tammy Long Hayward. This is the State Court of Clayton County, Georgia. I'm going to call the calendar and then we'll have announcements.
Excuse me, Judge, did we ever get a time for Mr. Brown?
Yeah, did we get Mr. Brown's turn in time?
Yes, Judge. So we would like to do 10 a.m.
Can he do 10 a.m.?
Yes, according to the deputies, there's no, it's anytime from 7 and then the latest time is either 5 or possibly 8, but I think Mr. Brown would like to turn himself in at 10 a.m. and I'm told that that is acceptable.
Okay, then if that works for them, that is a change in the previous policy. All right, so ladies and gentlemen, the first case on the calendar is Mariela Andrade. That's Mr. Rosenblum's case.
Your Honor, I spoke with Attorney Rosenblum. Your Honor, I spoke with Attorney Rosenblum last week. He sent me an email Friday afternoon informing me that he was going to be withdrawing the motions. I'm unsure if he filed a motion to a formal withdrawal of motions. If I may have one moment, I can confirm that.
Okay, thank you. All right, Adrian Lamar Brinson. This case was closed, and then it was some filings, I guess, a motion to plea and abstention for VOP, motion to dismiss detainer, motion for pro bono attorney pro se. So is Mr. Brinson here?
GDC just called. Judge, it might be a moment before he joins. They just got the Zoom information.
All right, and he's in custody in Department of Corrections?
Yes, ma'am.
All right, thank you.
Good morning, Judge.
Good morning.
This is Ms. Hemmings with the Department of Corrections, and I was just informed about the court hearing for Mr. Brinson. He will be up shortly, and I've just given them the meeting information to sign on.
Thank you so much.
You're welcome.
All right. Next is Jonathan Randy Campado. Mr. Florio?
Good morning, Judge. May myself and Mr. Tipton please have a brief pretrial with the court regarding that matter?
Yes.
Thank you, Judge.
And I'll set up a breakout and I'll draw in a moment. Next is Angelica Lozano. That's Matthew McNally. Angelica Lozano. It's a motion to suppress, and I do not see a withdrawal, but does anyone have any information about this?
Your Honor, the Angelica Lozano matter has been reset for pretrial diversion. We were not able to fully evaluate it because our pretrial diversion director is currently on leave, but she will be back tomorrow. And I've already recommended it to pretrial diversion, so we just need to have her review it and sign off on it to determine if she will take it or not.
All right, so the motion to suppress will be dismissed, and we'll do a status check on pretrial diversion. All right, Kiara Sincere Page.
Does that motion, I mean, that case was no pros last week.
What date?
24th.
Okay. Jalen LaRon Quarles.
Your Honor, we sent a PIA for Mr. Quarles. It's due on the 4th of this coming month.
Okay, so we're waiting a PIA motion will be dismissed on that. Kareem Assad Rogers.
Your Honor, Attorney Shipp withdrew his motion on Friday.
Okay. Adam Wiley.
Your Honor, Attorney Tortorella, Lister Holton Dennis, on behalf of Mr. Willie. Mr. Willie is not accepting the state's offer. We are withdrawing the motion to suppress on this matter, and he is not placed on a jury trial calendar yet, just to inform the court, and his not guilty plea remains, Your Honor.
All right, so Mr. Willie will be on the next available jury trial calendar.
Your
Thank
Honor,
you, Your Honor.
at
Yes.
this time, state's going to release its witnesses.
Okay, thank you.
And
All right, so that's the last case on the 11 a.m. calendar. I'm going to go back over it. So Andrade is withdrawn. Brinson is coming on from the Department of Corrections, and we'll speak with Mr. Brinson in a moment. Campado, we're going to have a breakout room. Lozano is withdrawn. I mean, it's dismissed for PTI.
Your Honor, I believe that because, and I apologize for interrupting the court, I believe that given that we are, since Ms. Lozano has not been officially accepted yet, state would request that just be reset. I don't think it'd be appropriate to dismiss it before we give a.
So we'll reset to the motion to pretrial. And that way, if she's accepted into PTI, we won't have to worry about it, but it won't go away. Okay, Page is no pros, Quarles is a plea in absentia, Rogers is withdrawn, and Willie is withdrawn and going on the next jury trial calendar. All right, so while we wait for Mr. Brinson, I'm going to set up a breakout room for me, Mr. Tipton, and Mr. Florio.
So, Mr. Tipton, your officer in the courtroom on that other motion is free to go, right?
We have, I have Investigator Robinson coming down to make sure that we're all up to date with all the subpoenas, and then he'll be released.
Okay, just making sure. Thank you.
Thank you.
Trying to find Mr. Florio. Mr. Florio, did I put him in a breakout room? Yeah. All right, he's in room number 2, Mr. Tipton. All right.
One moment, Your Honor.
All right.
Miss Hemmings, I sent you a chat on the Zoom.
All right, I am back. All right, so Ms. Val, Mr. Compadu's case, the motion is going to be moved to the pre-trial. So when he's on a trial calendar, we'll do it prior to the trial. The second thing is he's already scheduled for a bench trial at the 1 p.m. on July 30th at 1 p.m. We're going to remove him from the bench trial calendar because he had requested a jury trial. So we'll just move him to the next available jury trial calendar and take him off the July 30th, 1 p.m. calendar. So,
Yes, ma'am.
all right, thank you, ma'am. So I think the only thing we have left is Brinson. Ms. Henning.
That
Yes.
concludes my business before the court. May myself and Mr. Kempadu please be excused?
You may.
Great,
and
thank
it's Kimpadu. I think I was pronouncing it wrong. Okay, I'm sorry.
Thank you.
All right, yeah, you're free to go. All right, so Mr. Brinson.
Yes, ma'am.
All right, Mr. Brinson. So Mr. Brinson, you have motions before us for a motion for a plea in absentia for violation of probation, motion to dismiss detainer, and motion for pro bono attorney pro se. So I can grant you an attorney, but I'm trying to understand what it is you're asking for. So what I have is on your case 2018 CR 09436 before this court. You the first charge was no pros, improper lane change. The second charge, there was a plea to driving on a suspended or revoked license. And this case was then closed in December 10th of 2018. What is it you're asking for the court to do, sir?
I'll proceed without an attorney, so don't worry about the motion to for attorney. All right, but what I'm trying to do is I'm trying to resolve the whole issue today. I've been incarcerated for 8 years now, basically since 2017, and on an aggravated assault charge in which I have a 10-year sentence for, and that's these two detainers are the only thing that's keeping me from going to a TC to get out. So I'm trying to just resolve it all. Like I said, I've been basically locked up since then or whatever. When I first caught the charge, I was living in Texas, and when I was living in Texas, the judge was like, basically, we know you're not from here, so it was basically supposed to be a pay-only thing or whatever. But unfortunately, I had a warrant on me in Moultrie, which is Colquitt County, so I was sent to Colquitt County to go down there to resolve that issue, and I ended up staying.
You never completed the sentence in my case, is what you're saying.
Yes, ma'am. I mean,
okay.
I'll take read.
Just hold on a second. Let me figure out what that sentence was. Miss Wright, can you find that sentence in the case 2018 CR 09436, and let's see if there needs to be a modification so that we can go ahead and wrap that into whatever Mr. Brinson is doing right now.
Your Honor, I've already taken reviewing that.
Okay, go ahead, Mr. Tipton.
Okay, Your Honor. Case with regard to this case, count 1 was no pros, count 2 was a $500 fine. State would be willing to would consent to the state would be willing to consent to a modification of the sentence to 12 months to serve credit for time served since he's been in jail for so long, and we'd waive all fines.
That sounds good. Ms. Wright, is that something we can do?
Yes, ma'am, we can do that.
All right. Did you need Mr. Tipton to repeat that?
Yes, Your Honor. Count 1's been null prossed already. Count 2 will be suspended fine of $500, 12 months to serve, credit for time served.
Got it.
All right.
Thank you.
So, Mr. Brinson, the court is going to sign that amended sentence today. So that should relieve the retainer once it's filed and sent to the GCIC. Is there anything else that you needed, sir?
No, ma'am. How do I check up on it? Because I ain't gonna lie, ma'am. I done came a long way. I have stayed.
So, Officer Hemmings, is there an email address that we could send a copy to so Mr. Brinson could have access to it?
Yes, ma'am. You could send it to video.rsj video.hearing@gdc.ga.gov. And we can get it to him.
Okay, so what I have is video.hearing@GDC, Georgia Department of Corrections, initials, .ga.gov.
Correct.
All right, we'll get Mr. Brinson. Does that work for you?
Yes, ma'am.
All right, so
So-
that way you.
Oh, one last thing. Excuse me,
Yes,
ma'am. All right. What about remember that last year they gave me a court date last year, right? And just like I did this time, I had to go through the process of going through the court officer to get it, but they said I didn't have court then, so they put a detainer on me for a bench warrant. How do I resolve that?
We will do a search and I will release all bench warrants. Any of them would have come from me, so I can sign off on them. So
Thank you,
we'll
ma'am.
do bench warrant set aside. All right, and we'll send that to the same email address.
Okay. Thank you, ma'am.
All right, Mr. Brinson. Mr. Brinson,
Have a blessed day, ma'am.
the best thing to do is once you get out is to follow a different path. You got me? Don't come.
I learned my lesson. I promise
Don't
you.
come back down the same path.
Trust me, I learned my lesson, ma'am. It's been very hard on me, but I really learned my lesson.
All right.
Thank you,
Your
ma'am.
Honor.
Have a blessed day.
Your Honor,
Thank you.
I may have missed it, but did you want the state to prepare that order, or will the court be preparing that order?
If you could prepare that, well, no, if you could prepare the bench warrant set aside, I'll appreciate that. And Ms. Wright is going to do the resentencing, and I'll sign that.
Yes, Your Honor.
All right. Thank you, Mr. Brinson. Thank you, Officer Hemmings, for making this happen.
Yes, ma'am. Have a good day.
All right, you two take care. All right, so that concludes the 11 o'clock calendar, unless there's something I'm missing. Is there anything else outstanding?
No, Your Honor. Can Mr. Willie be excused?
Yes, Mr. Willie, everybody else on the 11 o'clock calendar can be excused at this time. We have completed all of the cases on the 11 o'clock calendar, and the court will be back in session at 1 p.m.
Your Honor, prior to the court leaving, may Mr. Lynch and I address with the court a matter involving the 1 o'clock calendar. Mr. Lynch made a request for a continuance, and the state is not objecting to it. There was new evidence that was discovered by our chief investigator that we believe that the defense needs to have that we believe the defense should be able to review, but was not.
Okay. You want to release your witnesses? Is that what you're asking?
We would just tell our witnesses not to even show up, Your Honor.
Yeah, that's fine. Which case is it?
Your Honor, it's Gary Williams. So the court's aware. The video in the case was misfiled under the wrong case number. So when we reviewed it with our chief investigator, he determined that there was a video, and I'm going to get with him later about preparing the video for Lister Holton Dennis.
All right, so we'll just reset the motion to suppress to right before trial in the Williams case, and then if you all reach some kind of agreement prior to that, then you can bring it on any of the calendars that we take pleas on.
Thank you, Your Honor.
All right, thank you. We'll see y'all at